Happy Constitution Day. So I do some writing having to do with comparative constitutional law. And in particular, I'm interested in how courts in different places handle constitutional rights. And lately, I've been working on a specific topic, which is how courts manage the horizontal effect of constitutional rights. To explain that, I'm going to draw a picture. So we normally think of constitutional rights as structuring the relationship between citizens and their government. Okay? So I have rights as against the government. If the state of Pennsylvania passed a law trying to censor what I say, I potentially have a First Amendment claim against the government. We think of this as the vertical dimension of rights because it's kind of the government above us, the citizens. And we tend to also think that rights don't have a horizontal effect, that is, don't regulate the relationship of citizens to each other. So if I work for a magazine and the magazine fires me because it doesn't like what I write, we think I don't have a constitutional rights claim. And that's true, but it's not true that rights don't ever have horizontal effect, that they don't ever structure the relationship between citizens. So if instead, the Westboro Baptist Church wants to picket the funeral of a serviceman with outrageous signs about how God loves dead soldiers, the family of the serviceman is going to be limited in their ability to collect a suit for intentional infliction of emotional distress by the First Amendment. So here a citizen can interpose a constitutional right to actually structure his relationship with another citizen. So I have a comparative project about how courts in different places manage the horizontal effect of constitutional rights. And if courts really let the horizontal effect of constitutional rights flow freely, it can actually really dramatically change the relationship between constitutional law and ordinary law, and the relationship between what courts do and what legislatures do. But that doesn't happen here. But what I think this does mean for the U.S. Constitution, one thing in particular, is that courts have an obligation, as they always do, to have law that makes sense. And the way U.S. courts think about this doesn't make a lot of sense. So we think about this in terms of the state action doctrine, the idea that generally you have to have state action, the government acting, to trigger a constitutional rights claim. But in fact, we have all these situations where that's not the case. And I think this matters because when you think about the horizontal effect of constitutional rights, you start seeing rights claims that we should take seriously, but that don't get a hearing because of the state action doctrine. So let me just give one example that's very timely. Cass Sunstein, who's a professor of law at Harvard, has a thing out today or yesterday saying that Black Lives Matter is the original meaning of the Equal Protection Clause. So what's his argument there? He said, well, the Equal Protection Clause actually creates a right established after the Civil War, during Reconstruction, at a time when African Americans' rights were being violated by mobs of other citizens, especially in the South. The 14th Amendment equal protection right creates a right to protection of the laws, to affirmative government action, to intervene to protect citizens against other citizens. This is a meaning that gets lost and obscured by the state action doctrine. And part of thinking about horizontal effect is a way to kind of uncover these lost meanings of constitutional rights.